10/2002. All are admitted facts.
Under section 4 is?
4 of the Land Acquisition Act 1894.
Yes, is?
That is not on, under section 4, 9/10/2002.
9/10/2002.
Then not 31/10/2002 is the declaration under section 6. Declaration. Number 23rd July 2004.
Just a moment. Section 6 का declaration का date बताइए.
जी sorry sir. 31/10/2002. 31st October 2002.
2002. Then
not 23rd July 2004.
23/7/2004. Award.
For rupees 68,240.
68,240.
Paid rupees 54,432. That is
54,432.
That is 80%. 80% of the
80%
total compensation.
Received on protest.
Received on protest.
On which date?
Yes, that is not. Then not on the same day. That is the receipt was made. Not that is recorded in the imping order.
23/7/2004.
Then not 3/9/2004.
3/9/2004.
This is not an application and extra one.
Application under section?
Under not 18(2)(b).
Under section 18 within bracket 2
small b.
Small b.
Of the LA Act 1894. That is Annexer 1 page 17.
LA Act 1894. It was filed before?
Annexer 1 page 17.
Filed
before the district. Before the land. Filed before the district land acquisition officer.
Land acquisition
officer. The collector under the act.
Yes. कहाँ का है?
ये वो जो गिरिडीह.
गिरिडीह.
Annexer 1 page 17.
All right.
Now
he kept mum.
Kept mum. Now our case is not on Annexer 2 page 25.
Annexer का कोई जरूरत नहीं, सिर्फ dates बताइए ना.
हाँ, उसका जो 22/7/2017.
22/7/2017. You filed a petition that it has to.
No petition, as per me. But
as per you, but it is said that you filed a petition.
Petition.
And upon your petition, it was referred under section 30.
According to them, 15/7/2017 is the petition. 15/7/2017, which is recorded in the.
Okay, 15/7/2017 petition filed.
Petition.
For
reference.
Reference under section.
It is an additional petition.
Reference under section 24(2).
24.
Of.
Under 64.
Under section
60. Reference is under section 64.
Under section 64 of the
new
new
Act 2013.
New Act 2013, and it was referred.
Then on 22/7/2017.
Yes.
That is reference Annexer 2 page 25. Here you lordship will find LA case number 11 of 2015-16 renumbered. Earlier it was LA case number 15 of 2002-2003. Earlier.
LA case number 15 of 2000.
11 of 2015-16. The process.
पहले पुराना नंबर बताइए.
पुराना नंबर जो LA case number 15 of 2002-2003. 2002-2003. And Annexer 2 reflects LA case number 11 of.
That's right, we got it.
Then
now
now
it has been held that it is not maintained.
Yes, rightly, because the only judgment of 5 judges bench lot, Indore Development Authority.
You don't need to say because you are not challenging that part that it is not maintainable.
That is not, in fact, not as the settled law will not. I cannot challenge it.
Certainly.
Because there must be two in condition.
भाई litigant को relief चाहिए, पैसा चाहिए. ठीक है. ऐसा लड़ झगड़ के सुप्रीम कोर्ट तक घूमने से कोई फायदा नहीं.
Another fact admitted, possession has been taken over.
Yes, possession taken.
Possession has been taken over. And admittedly 20% has not been paid.
20% has not been paid, and you are seeking enhancement also?
Enhancement of the entire amount, because that is the reference. Now, in fact, under the old act, it was to be referred to the district judge Giridih.
District judge Giridih.
As per the old act.
Yes.
Now, as per the new act, he referred it to the principal district judge, that is the authority under the new act. Authority under the new act.
Principal district judge.
Principal district judge, authority, Hazaribagh. Hazaribagh division will not consist of all the district. So therefore,
Authority under the new act.
new act 2013. No notice was issued.
Just
I
एक
appeared.
second.
Yes.
New act. Principal district is Hazaribagh.
Hazaribagh come authority under new act.
New act.
Yes. Then a notice was issued to me. It was registered as LAR case 7/17, 7 of 2017. I appeared. Both parties filed their written statement. Documents were filed.
That I have read.
And
Ultimately, it has been held to be not
why you
maintainable.
have to do
Even the limitation भी नहीं
नहीं
वो decide कुछ भी नहीं decide.
कुछ बोले कि आपको कोई
Maintainable ही नहीं है कोई जरूरत
maintainable
नहीं.
नहीं है. He is right. Number only 2 paragraphs of the
No,
judgment.
we have read it, Mr. Sani. We have
Both
read it.
parties rely. And
Whatever.
apart from this,
Just a moment. इतना जरूरत नहीं है ना. Not maintainable है ये इसमें तो कोई doubt ही नहीं है. Now the point for determination first appeal में बनाना पड़ता है. The point of determination is whether you will be left remediless because there is no observation made in the
Nothing.
first appellate
Nothing.
judgment
No.
that you can avail your other remedy,
Yes.
which is as per the Land Acquisition Act of 18.
apart, yes, that is there. But apart from this, only one proviso to 24 to make kindly be seen, Lord.
For what purpose?
For Act 2000, I am entitled to the calculation. Of course, it is not the.
That is not the subject matter. वो हम लोग decide
It
नहीं
is
करते.
for the district.
That is not the subject matter. Please don't indulge into.
And
that
the judgment
part.
also says.
बोलिए आपको क्या बोलना है?
Your Lordship, kindly have a look to the provision under section 64 of the 2013 Act, as well as section 74, through which the appeal lies before this honorable court. If your Lordship will permit me to read the section 64.
What do you want to say? पहले सेक्शन बाद में पढ़ेंगे. आप
हाँ.
क्या बोलते हैं कि जजमेंट गलत है?
नहीं, जजमेंट तो सही है.
ठीक है, जजमेंट सही है.
लेकिन appeal without no award has been prepared by the reference authority, by the LAR authority. No award has been prepared under section 69. And the what
Do you
section?
want to say that the appeal is not maintainable?
Yes, Lord. Appeal is also.
कहाँ है आपको कुछ फाइल किए हैं आप? ऑफिस का कोई ऑब्जेक्शन नहीं है
काउंटर
ऐसे
दिए
फ्री
हैं
स्टाइल.
लेकिन बोले नहीं.
ना ऑफिस का ऑब्जेक्शन नहीं है लेकिन
नहीं आप ऐसे फ्री स्टाइल नहीं है. Where is your objection that the appeal is not
whether I
maintainable?
will not be allowed to.
ऐसे नहीं होता है ना. You say there is no office objection.
Kindly have look only.
There is no petition from your
just
side.
for section 74 kindly have.
ऐसे नहीं होता है भी. इस तरह से फ्री स्टाइल में नहीं होता.
Your ladies is correct like but
इतना छोटा सा पॉइंट ऑफ डिटरमिनेशन है. उनको 20% भी नहीं मिलना चाहिए क्या?
वो तो हम उस पर कहाँ
फिर क्या बात है?
लेकिन एक ही सिर्फ इतना मेरा बेटा कोई अवार्ड बनाएंगे जो भी की नोट मेंटेनेबल उसका भी तो अवार्ड होगा तभी तो 70
कोई बात नहीं. नॉट मेंटेनेबल बोल दिए ना. अवार्ड तो ऑलरेडी बना हुआ है.
50,000 हुजूर हम
वो तो अवार्ड हुआ है जो
हुआ था ना award.
कलेक्टर बनाया था.
हाँ, कलेक्टर बनाए थे अवार्ड.
बनाया.
अब नया अवार्ड इसलिए नहीं बना क्योंकि कुछ बनने को था ही
नहीं
नहीं.
इन्हीं तो बनाते LAR
क्या बनाते? Not maintainable.
अपील नॉट मेंटेनेबल कुछ भी तो लिखते.
तो जीरो अवार्ड बना देते.
जीरो अवार्ड बनता तब जबकि वो नहीं इनहांस करते. आज
सब फालतू बात मत करिए. पैसा लैंड एक्वायर किए हैं. लिटिगेंट को पैसा लेने दीजिए. The remedy is under 1894 Act. क्या कौन सा
18 section 18.
सेक्शन 18 में 1894 है ना.
तो
1894 एक्ट में उसका रेमेडी है. तो वो he will avail his remedy.
हम उस पर नहीं है. अगर मेंटेनेबल नहीं है तो इनको तो लिबर्टी ऑलवेज देयर. लिबर्टी इज ऑलवेज बिफोर हिम.
सी में तो हम
अगर मेंटेनेबल नहीं है इनका वहां पर जो LAR अथॉरिटी लंदन प्रिंसिपल डिस्ट्रिक्ट जज ने लिखा जो हर कमिश्नरी वाइज LAR अथॉरिटी बनाए हुए हैं. तो अगर उन्होंने लिखा कि मेंटेनेबल नहीं है तब तो इनको ऑलरेडी रेमेडी और कोई चीज मेंटेनेबल
बस यही लिखा देते हैं कि ऑलरेडी उनको रेमेडी है. ही कैन अवेल दैट रेमेडी. काफी
75 साल का एज में हुजूर आप क्या
काफी है
करें?
ना.
25 साल तक खाए.
अब हम क्या खाएं? हम क्या
काफी मैंने रजिस्ट्रेट खाया. मेरा जमीन भी चला गया. 25 साल खाया भी पैसा भी रख लिया.
बाद में भी इन्होंने पिटीशन
ऐसे और आपत्ति करते हैं कि डिग्री नहीं बना और उसमें 50,000 कोर्ट फी दिए हैं. डिग्री नहीं बना.
FA number 196 of 2023 for the legal counsels appearing on behalf of the parties. This appeal is directed against the judgment dated 24th of June 2023 passed by learned principal district judge cum. इसका फुल फॉर्म बताइए. लैंड एक्विजिशन
राइट टू
नहीं ये कम Land Acquisition,
Rehabilitation and Resettlement Authority.
Rehabilitation and Resettlement Authority,
Authority.
Hazaribagh,
Yes.
in LR case number 7 of 2017, whereby the reference case referred under section 64 of the
Right to fair.
Right to Fair Act, of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 has been held to be not maintainable, and the same has been dismissed. The Learned Counsel for the appellant has, while giving the background as recorded in the impugned judgment, submits that it is not in dispute that the notice under section 4 of the Land Acquisition Act 1894 was issued on 9/10/2002. The declaration under section 6 was made on 31/10/2002, and award was prepared on 23/7/2004 for an amount of rupees 68,270, out of which 54,432, being 80% of the award, was paid to the appellant on 23/7/2004 itself, which the appellant received on protest. He submits that on 3/9/2004 an application under section 18 within bracket 2 within bracket B of the aforesaid Act of 1894 was filed before the District Land Acquisition Officer Giridi, and the same remained pending, awaiting reference, and in the meantime the aforesaid Act of 2013 came into force. He submits that as per the impugned judgment, on 15/7/2017 a petition was filed to refer the dispute under section 64 of the new Act 2013, and consequently a reference was made on 22/7/2017. He submits that the earlier land acquisition case was numbered as LA case number 15 of 2002-3, and it was subsequently renumbered as land acquisition case number 11 of 2015-16. The Learned Counsel submits that it is further not in dispute that the possession of the land was duly taken pursuant to the acquisition made under the Act of 1894. The Learned Counsel submits that that a number of issues were framed, but the Learned Court ultimately held that the reference itself was not maintainable. By referring to the judgment passed by the Honorable Supreme Court in the case of Indore Development Authority versus Manohar Lal and others, reported in bracket 2020 bracket close 8 SSC 129. The Learned Counsel submits that the reference having been held to be not maintainable, the right of the appellant to get the matter referred by the District Land Acquisition Officer Giridi in terms of the initial application for reference, which was to be referred under the Land Acquisition Act of 1894 to the concerned district judge at Giridi, is required to be protected. He submits that the impugned judgment does not indicate anything to the aforesaid effect, and therefore appropriate order is required to be passed. The Learned Counsel for the respondent has submitted that once the reference is held to be not maintainable, there is no need for any observation and it is certainly open to the appellant.
इसको
तो फिर क्या बताएं? यही बोले हैं?
judgment requires no interference.
हाँ?
Judgment requires no interference.
Okay, the learned counsel has submitted that the judgment requires no interference. And the same has been passed in accordance with law. After hearing the learned counsel appearing on behalf of the parties and particularly the argument advanced on behalf of the appellant, whose grievance is limited to the extent that the right of the appellant to get the reference made under the provisions of 1894 Act is required to be kept intact. This court is of the view that the following point for consideration arises in the present case. Whether the learned trial court having held that the reference was not maintainable under the new Act of 2013 ought to have observed that the appellant may still approach the District Land Acquisition Officer Giridih for seeking reference in terms of the old Act of
That I have already
1894.
approached in 2004.
That's in connection with which he had already approached way back in
Annexure 1.
2004.
Annexure. Page 2.
Considering the totality of the aforesaid facts and circumstances, this court is of the considered view that this court finds that the learned appellate court has recorded a finding in paragraph 13 by deciding issue number 1 with regard to the maintainability of the reference and has held that the new Act of 2013 is not applicable in the instant case and therefore the reference is not maintainable before the authority who is not empowered to entertain reference under the old Act of 1894 and is only empowered to entertain reference under the new Act of 2013. This court is of the view that merely because the learned court was not entitled to entertain the reference under the new Act of 2013, the right of the appellant to get remaining 20% of the awarded amount and also get the matter referred to in terms of the Act of 1894 before the competent authority under the said Act has not been lost. And therefore, it is certainly open to the appellant to take appropriate steps in terms of the grievance of the petition appellant with regard to compensation is taken care of.
The district land acquisition officer whom I have already
So that I have already recorded.
Yes.
This
Time
appeal
frame-
is accordingly.
Time frame otherwise not 20
This
years.
is not
sir.
under,
कुछ नहीं होगा.
sir, this is not under Article 226.
This appeal is accordingly disposed of. Yes.
Because we have the already
In
it is
terms
on
of the
record.
aforesaid observation.
It is already on record.
हो गया
that in
सर, हो गया सर,
2004 I
please.
have-
आर्टिकल 226 नहीं है सर, आप वो
आर्टिकल 226 कहाँ पर है?
इतना ही काफी है सर.
आर्टिकल 226 का आपसे सीखना पड़ेगा।
नहीं हम तो
Next
already
case.
हम तो
आप भी से सीख रहा
नहीं हमसे क्यों सीखिएगा सर, आप सीनियर
आप भी तो सिखा रहे हो
हमने सीखा है।
From date list password is Title 15, second Appeal
20
240
years
of
past
2018.
75 years
तो
old
हो तो गया।
Yes. Appellant. Who is the appellant? आपका ये है? हाँ लाइए. पहले उनका.
Leadership paragraph 3 and 4.
ये आरडी सिंह कौन है?
RDC proprietor.
Proprietor is 79 years old.
Yes,
He is not able to.
his
swear.
document I have filed to show why he could not come to swear the
Okay.
affidavit.
And he is attending his father, Sachindanand Singh.
Piyush.
Sorry, Piyush. Okay.
So RD Singh gave me an affidavit day before yesterday, before he left for Hyderabad from Ranchi. That affidavit is at page 8. Because whatever facts he said about Piyush, on face of it, I could not take it to pass on to the court.
So you need 20 days time.
Yes, at least.
देखिए आइए नंबर जो भी होगा. An interlocutory application has been presented before this court. Seeking an extension of 15 to 20 days for complying the order dated 14/1/2025, whereby the appellant has been directed to produce the original of the documents which has been attested copy of which has been annexed along with the interlocutory application seeking adducing of additional evidence. It has been pointed out that Mr. Piyush Ranjan Singh is the custodian of all records and he is attending his ailing father, Mr. Sachidanand Singh, in P.N. Birla Hospital at Kolkata. Considering the facts mentioned in the interlocutory application, the matter is adjourned and is directed to be posted on
Lordship, one small prayer, Lordship. It may kindly not be posted in date between 21st to 28th of February. Senior difficulty. Before 21st of February.
12th of February. Correct? Post on 12th of February in the supplementary.
Very deeply obliged.
I disposed of.
To be recorded in the absent a copy of this IA because the service is.
करवाइए ना? करवाइए उनसे.
Actually, I was not knowing that he is there, so I was looking for a counsel.
Also, case item 15 from Delhi list. SA 240 of 2018.
You have seen it?
Yes.
कौन सा वाला? नहीं एक जो partly सुने first half में. Where is that? Yes, you were there.
That is matters I'm paying for.
For what?
So Roy has to get it. He's
देखिए,
not in
merely
my lord,
to
I-
record an appearance, the case will not be adjourned.
Also, my lord, I tried to check the records. The records of the LCR of the execution case is not there. It
Not
will be
required.
recorded.
Not
Because
required.
they are trying to make out a case that it has been disposed of without hearing them, which is not true.
No, no, no,
Therefore,
that
the
is not
records
their
are-
case. Their case is that no evidence has been laid. It is not their case that it is an ex parte
So
order
if
or it
sufficient,
has.
so if sufficient offers, because what they are trying to make out a case of adverse possession, there is no pleading to that effect in their petition under order 21/97.
No, it is very much there.
No, but the requirements of adverse possession, all the
That
requirements
is,
has
therefore,
not been
therefore, this point whether the requirement of the basic requirement of adverse possession is there or not was required to be adjudicated.
But with
The entire case has been adjudicated on the basis of pleader commissioner's report, which is a part of the record of the title suit, where they are not party.
I'm only one adjournment.
No,
Mr. Roy has to. The order may be passed in his presence.
no, no. What do you mean
I
in
wouldn't
his
have been
presence?
present. I wouldn't
Ask him
have-
to join online.
I wouldn't have been present.
Ask him to join.
He's in Kolkata on account of some medical.
This is not done.
And the order sheet of the execution case would be required, because if they were given an opportunity to lead evidence and they did not, then there is no case.
That is not the case.
But it is not reflected from, because the impugned order is a very recent order and even
You
the
show
appellate
us
courts
from
order.
the impugned order that they were given opportunity. The impugned order is based on the pleader commissioner report of the. I can understand it. The case could have been dismissed on the ground that they did not lead any evidence. Fair
In
enough.
2197 minus, I can try to find judgment minus that it can be dismissed at admission stage itself, because the first requirement of 2197 is that they have to establish an independent right from the judgment date.
You see, you are in the second appellate stage. We will see the judgments. The judgment has been passed on the basis of the records of the partition suit. Whatever is there, it is not your appeal. The judgment is referring to the pleader commissioner's report at the stage of partition suit. On that ground, they have given a specific ground to reject it.
Yes, and it has also been recorded in the judgment that no chit of paper has been submitted by them. So it is incorrect to say that they were not
For the
given opportunity.
purposes of adverse possession, what sheet of paper? What sheet
They
of
will at
paper
least
I
have to
got?
show how they, because this is a
Therefore, evidence was required to be made.
So therefore, I was trying to check the order sheet of the execution case. Because why the execution? Otherwise, also, my lords, 2197 can be dismissed at the admission stage itself if the initial requirement is not fulfilled.
What is the
The
initial?
initial requirement is that they have to establish an independent right from the judgment debtor. For that, they will have to show how they came
From
into
the judgment debtor?
Yes.
No.
Yes. They will
They
have to.
get, no.
If they are claiming their right through the judgment debtor, then there is no scope of 21.
There is no scope. They are claiming right independent of judgment.
So that is something that has to be established. They have not pleaded anything about how they came in possession. When did their possession became adverse? There is no pleading.
That
They are
is-
just saying that we are in possession of the
That
land
is
for
not
more
the
than 50
reason
years.
for dismissing their petition. The
But-
reason for dismissing the petition is that they were not found in possession at the time when the pleader commissioner was there. That is the reason for dismissing the petition.
They were leader commissioner had stated that they were encroachers. So
It
their
is from
claim.
which district? District child. टाइम लेने के लिए बिना कारण के टाइम लेंगे ना, तो जब कारण होगा तब कॉस्ट लगा के टाइम
नहीं,
बिना कारण के
it's a
टाइम
genuine cause. She is
What
not in
genuine
Nazi,
cause?
otherwise I wouldn't have interested.
अगला दिन आके वो नया कहानी सुनाएंगे।
पहला वाला सेकंड अपील पढ़ गई सीरियल 15
इतना सिंपल सा चीज है, क्या है इतना? फिर वो आके बोलेंगे रिकॉर्ड मंगाइए, ये करिए, इतना सुनिए
record
तो-
would be required minus the
What
execution
do you-
records of the execution.
आपके कॉस्ट पे मंगाते हैं, जमा करिए स्पेशल मैसेंजर कॉस्ट, डिपॉजिट द स्पेशल मैसेंजर कॉस्ट। द लर्नर काउंसिल फॉर द ऐसे नंबर 88 ऑफ 2019, ये तो आ गया है, नहीं एग्जीक्यूशन केस का पास में। The learned counsel for the appellant has submitted that at the stage of execution
was already
proceedings,
called. The LCR was already called for.
execution केस का रिकॉर्ड नहीं आया, हम चेक कर लिए, आप लोग नहीं चेक किए। The learned counsel for the, इसीलिए बोले थे ना हमको पिटीशन नहीं मिल रहा। The learned counsel for the appellant has commenced her argument and has submitted that the points of law formulated, substantial question of law formulated by order dated 13/5/2019 is fit to be answered in favor of the appellant. She submits that the appellant was not a party in the partition suit and filed a petition under order of 21 Rule 97 and 99 of CPC and claimed independent title. The appellant also claimed the appellant claimed to be in possession of the property for more than 50 years and claimed adverse possession. She submits that the learned trial court, the learned executing court referred to the pleader commissioner report, which was a part of the partition suit proceedings in which the appellant was not a party, in order to reject the petition filed by the appellant. She submits that she submits that adjudication under Order 21, Rule 97 and 99 assumes the character of a decree and no evidence was permitted to be read, and the petition has been dismissed without the petition has been dismissed summarily by referring to the records of the partition suit. The learned counsel submits that even the appellate court has not considered this aspect of the matter, and therefore the points of law are fit to be answered in favor of the appellant, and the matter is required to be remitted back to the executing court for considering the petition on merit. The learned counsel for the respondent has submitted that it was for the appellant to lead evidence before the court, and since the executing court record is not available before this court, it is not clear as to whether the appellant had led as to whether the appellant did not lead any evidence in spite of granting opportunity. He submits that the records of the executing court be called for. Let the records of the executing court in execution case number
20 of 2016.
20 of 2016 be called for at the cost of at the special messenger cost to be deposited by the respondent
Your
by
Lordship,
Monday.
There's an IA that we had filed for stay of that execution case because the lower court is proceeding in the matter. So as on date, status quo may be maintained. IA number 33 of 2024.
Since the proceeding of this case has commenced, the IA number 3805 of 2019 seeking stay of the
33 of 2024.
Do I wonder
seeking stay of the execution proceedings. Is allowed till the next date of hearing. Accordingly, further proceedings in execution case number
20 of 2016.
20 of 2016 pending in the court of civil judge within bracket senior division bracket close -1 at Chaibasa is stayed till the next date. बताइए कब करेंगे? Pose this case on 11th of February in the supplementary cause list. Stay till 11th of February. Let this order be communicated through fax. आप अपना जमा करेंगे. Special messenger post. ये order communicate करना है CBS को. Type करना है.
Item 15, second appeal 240 of 2018.
Structural question of law was formulated by order dated 23/8/2022.
You wait for some time. There is one partner matter. Yes, you just come. Mr. Rao, your matter is partnered. We heard it yesterday.
Yes.
We finished. Like, we did it. 2:15 में fixed है ना? You just wait for some time.
Item 1 from supplementary list.
Yesterday, your lordship wanted to know what were the evidences with regard to payment of rent by the defendant to
See,
the
that was just whatever we have said. You just come to the question of law and you start arguing one by one.
Yes.
Let's see first question of law.
I'll answer to this, but your lordship, the pleadings is important.
No, you answer it. If whatever you want to take, whatever you want to show from the pleadings with regard to question number 1,
Yes.
kindly refer to that. We will go one by one.
Okay. So, your lordship, the first question is whether the certified copy of registered sale deed number 428 of 2008 dated 17/7/2008 would have been exhibited on the date of judgment as a public document. So my answer would be no. In view of, your lordship may see order 7, rule 14. Order 7 entirely deals with what would be there in plaint. Order 7 is related to plaint. The heading is plaint, and the relevant rule is Rule 14. It says that production of document on which the plaintiff sues or relies, where a plaintiff sues upon a document or relies upon a document in his possession or power in support of his claim, he shall enter such document in a list and shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaintiff. Where any such document is not in possession or power of the plaintiff, he shall, where possible, state in whose possession or power it is. A document which ought to have been produced in the court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of this. So absolute specific bar that it shall not be subsequently.
No, it can be subsequent.
Yes,
With
yes,
leave of the
with
court.
leave of the court, absolutely. I stand corrected with regard to that. Subsection 4 is the exception. Now, in which circumstances 1 to 3 would not apply, is that nothing in this rule shall apply to a document produced for cross-examination of the plaintiff's witnesses or handed over to a witness merely to refresh it.
That's
So here it is not this case, that it is covered by Rule 4. So it was absolutely covered by Rule 1, and they were required to firstly give a copy along with the plaint, and they did not do so. Then, Your Lordship, identical provision is there in Order 8 Rule 1, identical, but that applies for the defendants. If the defendant is relying on a particular document, he also has to.
we are not concerned.
No, we are not. I'll just for complete argument. Now, Your Lordship may kindly take up Order 30,
Order 13.
Rule 1. So under Order 7 Rule 14, a copy can be filed along with the plaint, but the original has to be filed before in terms of Order 13 Rule 1. It says very clearly, the parties or their pleaders shall produce on or before the settlement of issues all documentary evidence in original where the copies thereof have been filed along with the plaint or written statement. The court shall receive the documents so produced, provided that they have been accompanied by an accurate list thereof prepared in such form as so and so. And then again, nothing in this rule shall apply to so and so. Again, repetition of. So my contention is, firstly, the moment a plaintiff files a suit, the document which he is relying, either he has to produce the original or at least a copy thereof along with the plaint. At best, if he does not do so, then he has to produce a copy, and then the original has to mandatorily be filed before the settlement of issue. This was not done. Then subsequent provisions are there that the settlement of issues would take place and then evidences would be led, and all those things are there. So he does not do so. He directly produces and files a document, and the court accepts it on the date of judgment. So I never got a chance to rebut that or even to look into the document of transfer on the basis of which the plaintiff was claiming, because it was very specific case. My case was that I had denied the transfer, I had denied acknowledging him as landlord.
You have not denied the transfer.
I have said what I have said. Therefore, I said that
Transfer is not denied. Your case was that it was agreed that this property will be sold to you.
No. Entire written statement may be seen.
Yes.
Why I said that, I have said that if there is any transfer, then only I have said. If there is any transfer, then he is bound to honor the lease deed, terms of the lease, not otherwise. May I read the pleading from the trial court judgment? The pleading has been mentioned.
No, we will read the pleading from the plaint and written statement.
Your Lordship may take up internal page 5 of the trial court judgment, and in the middle portion, it has been mentioned, para 6, 7, 8 of the plaint are untrue and denied. The alleged sale deed is an illegal instrument by which the Bhagwati Prasad Parsuramka could not legally convey the suit property to the plaintiff. There was a condition attached to the
The execution of the sale deed is not in dispute. What is in dispute is that he should not have done it.
he could not
Because yes.
because he
there
had-
is already a tenancy over the premises.
Tenancy, and
and
he
they
had-
put that too with a condition.
The tenancy lease deed itself contained a
That's
provision
it. So
that
there was an
it would
objection
be,
to that.
yes, it would be for me, for the lessee to seek renewal and get the,
That's
it was not optional for the landlord.
That's right. So sale is whatever the right of the landlord. Nothing more and nothing less.
And he would step only with regard to whatever property that has been transferred. I do
Certainly,
not say that.
you see, your landlord will be replaced. Nothing more. If you have any right under the lease deed, that right will be renewed. That right will, he is bound by that right.
Obviously, so
Execution of the sale deed is not in dispute.
So let us assume that it is not in dispute. So the lessee or the transferee, that means the vendee, it would only step into the shoes of the
Yes.
my lessor only to the extent of the property that has been transferred and not beyond
Only to the extent.
that. That has been transferred to him.
That's certain.
He could not have. And the,
So therefore, your contention is that this particular document could not have been admitted into evidence.
why, therefore,
No,
why
why
it has,
let's assume that it could
Yes,
not.
yes.
Let's
Why-
we take it that it could not have been done in that manner.
yes,
Then that has to be excluded. We will
yes,
exclude it.
excluded,
We'll exclude it.
yes, yes,
Now we will see that what is the consequence.
yes.
Let's see.
Your Lordship will see. Then because what I say in my written statement.
So therefore, according to you, if point number 1 is answered in your favor,
Yes,
then point number 2 is to be seen, right? Because so far as the appellate and trial court is concerned, whether they have exclusively relied upon this particular sale deed or said anything about it regarding it, and then point number 3.
the
That's all.
trial court has relied on this document and therefore it has passed.
Is this the only document which has been relied upon?
There are other documents.
There are other documents also,
Yes,
there
yes.
are other conducts also.
Yes, yes, absolutely, absolutely. I'll come to that also. So
So that is not
basically
the
now,
solitary document on the basis of which
basically
the
now it
the-
has to be seen whether I had admitted him as my landlord or not.
That's it.
This is the crux of the
This is
entire
the crux
dispute.
of the matter.
Now your Lordship may see after 4 lines of that particular portion which I was reading, I have said very clearly last 4-5 lines. Page 5 of internal page 5 of the trial court. Defendant never paid rent to the plaintiff since he did not recognize him as a landlord of the suit property. Defendant all along paid rent to Bhagwati Prasad Parshuramka, but when he refused to accept the rent, then rent was sent to him by postal money order. To him means to Bhagwati Prasad Parshuramka, not to the plaintiff. Sometimes he used to accept the rent and sometimes he used to refuse and then so and so. So very clearly I have said that I do not recognize him as my landlord and I have never paid rent to him.
So, and in what evidence did you produce with regard to postal money order?
With regard to?
Your specific case was
Place relevant evidence only. Your Lordship may see his evidence only. I'll place one by one.
no, it's not. You said that you never paid rent to the plaintiff.
Yes,
You paid rent to Parshuram.
yes, his vendor. My original list.
And you said that you paid rent to him till the expiry of the lease deed, right?
Yes.
That is till
Till October 2011.
What I have to show your Lordship,
October 2011.
what I have to show
These
that the property, the sale deed was executed on, that date your Lordship may take into consideration. The date is 23/7/2008. This is the date of the sale deed. And I send money order on 21/10/2008. This is post alleged transfer. And this is being received by my Bhagwati Prasad Parshuramka. This is the exhibit B. So even after transferring, if he was still receiving the same amount, your Lordship may see exhibit B. Exhibit B.
Yes.
This is money order form dated 21/10/2008.
Yes.
And the amount has been received by Bhagwati Prasad Parshuramka. Bhagwati Prasad Parshuramka never came in court in support of the plea that he had not signed this document, or they did not even summon him. So this thing is proof that he had accepted. There's absolutely nothing on record to show that I had paid rent to him. And this your Lordship may kindly see his own evidence. I'll point out. He was examined as PW1.
No, you see, your case that you kept on paying rent
Yes.
till October 2011
Yes.
through money order is not on record.
So my statement is there. So my new, at best, what would it be? That I am a defaulter.
Yes.
But I would be a defaulter vis-a-vis my earlier landlord, not against him, because I am not recognizing him as my landlord.
Did this Parshuram ever informed you about the transfer?
Yes, he had it.
Exhibit 2.
He had said so.
He has said so. That has
but
been proved. That
that
he has
has been-
transferred the entire property in
No,
their
no,
name.
no.
Yes,
He
yes.
does say that he has transferred the property. He does not. So, Your Lordship, would that override the exhibit by which he mentions the deed, sale deed date, that this is the deed by which I have transferred?
It has been mentioned in his letter also. This is
Yes,
the
but
deed it has been
I have
transferred.
transferred it by this sale deed, and my learned friend admitted that absolutely there is no other sale deed, and that sale deed is only with regard to 21.
No, we are not looking at that sale deed. That is excluded. Not properly exhibited, not properly taken into record. That has to be excluded because your point number 1 is that it has not been properly exhibited. It has to be excluded. We'll
Yes,
exclude
yes,
it.
yes.
Now we are examining that
So,
even
yes,
if we exclude that
absolutely,
sale deed,
absolutely.
what is there on record,
Absolutely.
whether still the decree can
Absolutely.
be sustained. That's it.
So if that is excluded, then the statement with regard.
Not the statement.
Yes.
We will see the findings.
I'll come. I'm answering Your Lordship's query. So, Your Lordship, then if that is excluded, then this statement that I have transferred it to him, this is also excluded. How can a portion of it can be taken? Yesterday this was the question that fell. Only a portion of it I cannot accept,
no,
and
it's
the
not
other
that.
portion I
It's
cannot.
not. You see, there is the pleading that it has been transferred. There is an admission also that it has been transferred. But you say
So
that it
let us
could not have been
assume
transferred.
let us assume that today I write a letter. I have transferred the property to this particular person, and you acknowledge him. Then would it be binding on the lessee to accept him as a landlord?
You
Because
have
I
paid.
have not
You
accepted.
have paid money also.
No, I have not paid.
Exhibit 3.
I have not paid. If I have paid, I am out of court.
Exhibit 3.
I'm
That is
not-
the finding of both the courts.
No, absolutely erroneous finding. Therefore,
But that is not the question of law here.
therefore, Your Lordship, I was
That is not the question of law here.
for appreciation of anything, it has to be seen at that exhibit 3. If Your Lordship says, then exhibit 3 has to be seen.
That's right.
Exhibit 3, Your Lordship may see.
What I am looking at is that there is a finding that
What?
you are a defaulter.
Yes, what is exhibit 3? That Your Lordship would see. Your Lordship may see exhibit 3. Exhibit 3 is their own account
Yes,
that Your Lordship may see.
that's right.
And what is the monthly rent? Monthly rent in the lease deed was 2,000 per month. And what is the amount that it is their own document. And what is it is showing? 7,000 on 5/11/2008, 5,000 on 26/12/2008, 5,000 on so and so, and all these dates are there. It does not correspond to the rent for which period I have paid. And Your Lordship may kindly calculate the entire amount from this the date of transfer till 3/10/2010. I have calculated, and this is the amount from 23/7/2008 to 3/10/2010. There were altogether 27 months, and for 27 months, in terms of 2,000 per month, it would have 54,000, and the total of this amount is 73,000. So how does he prove? And when we cross-examine him, he says that this is my own account, this does not even bear my signature. This was put in its cross-examination. This does not even bear the signature of the lessee, that means me, and it does not even bear the signature of the person who has produced
It
this
is
account.
their record that they are maintaining. It is their own record that they may not have a signature. Every page of the
May not
statement of
have,
account.
but how can this be taken into to show that I have paid rent to him? Their own record would go to show that they have paid rent. When I have specifically denied, when particularly I have produced a money order to show that even after
Only
execution,
one money order.
absolutely.
Only
So-
one money order of the year 2000.
Yes,
of
yes,
July
yes. But
2008.
yes, but even after transfer, he has accepted, and this.
Where is
This-
the proof that you have paid it to the ex-landlords? Where is the proof?
There's nothing.
There is nothing.
No. After
And you claimed that you have been paying rent.
I have said so.
You have
I've
said so that you have been paying rent. You have also said so that some money orders were returned. There is no such evidence.
There is one more document is there, but your Lordship
No,
has
that
seen.
return money order is
Exhibit
not
C.
there.
Exhibit C. But this was refused.
Exhibit C is dated.
This 11/2008 it was refused.
And then apart from that, you also sent a letter to him for renewal of lease.
No, therefore I say all these things are good. Your Lordship, whenever that is referred, that letter has to be seen. And I may be allowed to read that also. I'm reading what it says. Again, I'll say that only a portion of my evidence cannot be used against me.
See,
An entire
execution
letter
of
has to be
the
seen.
transfer is not disputed. What is disputed is that it has been illegally transferred.
No. I'll read out entire
Read out.
document itself. Your Lordship may allow me to read. Your Lordship,
रिटर्न हुआ
that
एग्जिबिट सी में क्या बोल के रिटर्न हुआ है? महाशय आपका घर anyways whatever it is we are not going to deal with that.
नहीं रिफ्यूज्ड है. ये तो हम लोग लिखे हैं. Whenever the sender sends some money, then he is
अच्छा
required to.
रिफ्यूज है यहाँ. महा 2008 है ना, 2008 महीने का कोई आपके
सितंबर में.
सितंबर 2000.
Exhibit 6, Your Lordship, because that is the document which Your Lordship is.
एग्जिबिट
6.
नहीं, एग्जिबिट A by 3 देखिए ना,
हाँ A by 3. ठीक है. Exhibit A by 3.
पढ़िए.
Exhibit A by 3. Last.
नहीं नहीं, पूरा ही पढ़िए ना.
पूरा पढ़ दे रहे हैं, ठीक
हाँ
है.
एकदम पूरा पढ़िए.
हाँ, but relevant is at
आप पढ़िए, पूरा पढ़िए.
हम पूरा पढ़. With reference to your notice dated 22/10/2011, I have to say that the contents of the said notice are mostly distorted and partly false. The notice is also modified and motivated and has been sent in conjunction with Bhagavad Prashad Parsuramka. The alleged, time and again I am using the word alleged, I am not admitting. Alleged sale of the premises in question to your client is illegal and void, and he has not acquired any kind of right to the property by your alleged purchase. That during my tenancy, I have constructed several new structures on the premises as per stipulation of the lease deed, but it appears that Bhagavati Prasad Parsuramka has not mentioned those structures constructed by me in the sale deed in a dishonest manner. He also suppressed the fact that of the existing lease in the sale deed and everything was done on your advice. That the description of the structures constructed by me are given below. a shed of so and so, valued at rupees 5 lakh, mother shed of so and so, we valued at rupees 2 lakh, one pakka building with RCC room.
ये सारी चीजें वो लीज डीड देख, सेल डीड देख के बता रहे हैं. You just see your conduct. It is very much within your knowledge. You are very much aware that there is a sale deed, and you are saying that yes, this sale deed has not been properly executed. गलत है, उसमें गलत description है, गलत लिखा है. लेकिन sale deed हुआ है, ये कहाँ denied? You forget about the registered sale deed. Sale deed is an admitted document, need not be proved. Is at least the execution of the sale deed. And there is a finding that you paid rent. उसके beyond हम लोग क्या ही देखें?
But that finding is only with regard based upon Exhibit 3, which is their own document.
Exhibit 3 पर तो कोई question of law ही नहीं frame हुआ यहाँ पर. There is no question of law framed under for Exhibit 3 that it has been improperly construed or nothing is there.
But even if I was aware, it is only related to 21 decimals. It cannot.
That is not a part of the
Absolutely.
record. That is excluded.
No landlord-tenant relationship with regard to the other portion with regard to
You see,
it mainly.
just a moment. Where is your lease deed? Where is your lease deed? Exhibit? Exhibit 1. Badi.
Entire law.
No, इसमें assign भी है कि नहीं? है ना?
इसमें है and 2000 per month was the rent.
Where is it assigned?
It is there in internal page 3 at the top. Monthly 2000 per month.
Enhancement is also there.
So if enhancement was there, then what was the enhanced amount? That is not
tally.
Includes heirs, executor, successor, representative, administrator, सबको include करते हैं.
Absolutely.
अगर लैंडलॉर्ड बोल दे कि मिस्टर एक्स को आप पेमेंट कर दीजिए
100%. It would include
और
all.
on the face of exhibit 2
But only with regard to the portion actually transferred. It cannot mean.
देखिए आपने बहुत डीप पढ़ा है, उसके बारे में रेफर कर रहे हैं. आपका कोई ऑब्जेक्शन रिटन स्टेटमेंट में
हम
भी
क्या
नहीं है.
ऑब्जेक्शन कर रहे हैं? हम तो deed का हम on the first date I said that I cannot become the owner of the property, but I'll at least what I say that as regards the property that has been transferred, I'll become a lessee with regard to the subsequent purchaser, but not with regard to the other portions.
तो
How can
you
that
want to
say
say
be
कि
used?
2011 में लीज खत्म हो गया है, बस you will continue in possession of the property. ना ओरिजिनल लैंडलॉर्ड को कोई लेना देना है, ना सब्सिक्वेंट
So
लैंडलॉर्ड
original landlord would file a suit against me with regard to the property which has actually remained untransferred. How can he, on the basis of that transfer, he can?
we are not referring to that exhibit, no? उसको exclude कर दीजिए, उसको हर चीज उसका exclude कर दीजिए, उसके बारे में हम लोग कुछ नहीं देखेंगे ही नहीं उसको.
So
Because it is not a part of
then
the
how can that knowledge of mine,
We are not saying
that
anything.
statement can be taken into consideration?
we are not taking anything into consideration. उस deed में जो लिखा है उसको हम लोग नहीं देखेंगे, क्योंकि वो deed ही नहीं देखेंगे. That has not been properly exhibited, that has not been properly included. तो वो तो exclude हो
हम
गया.
कोई reason से मेरा argument था पूरा ये में that if it would have been produced at a particular point of time, then I would have the opportunity to say that this does not relate to the entire suit property. It only relates to a portion of it. So I did not get this opportunity. And the eviction decree is against all, and whereas the sale is only with regard to a portion of it.
That's all.
And the last is, Your Lordship, because my argument was to be taken, the same letter which I was referring, Exhibit A by 3, last line I have said, last para 9 and 10, that if according to your claim, your client has stepped into the shoes of Bhagwati Prasad Parchuram ka by purchase of the suit property, then he is bound to renew. I say that if he has stepped, and then I say that I have never paid rent to your client, but I am always remitting rent to Bhagwati Prasad Parsuramkar, and I have never defaulted it. So this is
So there is no evidence with regard to continuous remitting of rent.
it is not.
Bhagwati
But
Prasad.
only the Bhagwati Prasad Parsuramkar would have a right to sue and get eviction, not a person who has only purchased a portion. As regards the property purchased, I say that I do not have. Because the moment the transfer is by registered deed, the transferee would be stepped into the shoes of the vendor, but not with regard to the entire. That is my view.
So, if issue number 1 is answered in your favor, then issue number 4 need not be answered, because there is no other material apart from the sale deed with respect to issue number 4. Apart from the sale deed, is there any other material?
Apart from the sale deed,
If the sale deed is to be excluded, since it has been wrongly taken into record at the date of passing of the judgment, then under such circumstances, issue number 1 stands answered in your favor. What is the consequence? It has to be excluded. That will stand excluded. Then what will happen to issue number 4? Because if that is excluded, we cannot read anything from that document. So, is there any other material from the record which supports contention with regard to issue number 4?
no.
No. So,
Because
therefore, if issue number 1 is answered in your favor, then issue number 4 becomes redundant because there is no other material.
no.
Correct?
Then another question would arise. If this is answered in my favor and the sale deed is taken off the record, then my pleading or my denial that he is my landlord does
That we will see.
Absolutely
That we
does
have
not
to see. That we have to see.
because there is absolutely no evidence.
There is an admission that the property has been sold.
So that sale again that sale, how can that be taken into consideration?
It is an
Therefore, I said
admission.
that it cannot cut both ways. Either same question.
You see,
which
it
your
is
Lordship
one
had
thing
said.
to say that the sale deed is not exhibited. It is another thing to say that the sale itself is disputed. Sale is not disputed. The point is that the sale deed was not exhibited. Sale, the factum of sale is not in dispute. The manner in which it has been sold is in dispute.
Not sold, it has been exhibited. It has been exhibited, and because there was a clause in the lease deed that I would have
So
the
you have
absolute right of
questioned the manner in which it has been sold, the purpose for which it has been sold, but the factum of sale is not in dispute.
So yes, factum of sale is not in dispute. Then again sale deed comes. Again
Then-
sale deed comes.
No, factum of
Sale deed
sale.
has to be excluded altogether, or it
No,
has to be
sale
taken
deed
into
will be
consideration.
excluded. But what about your pleadings? That will not be excluded.
So my pleading is that I do not accept him as a
No,
landlord.
you don't accept him as a landlord, but the fact that it has been sold is not in dispute.
So I have.
No, so we have to see the consequences. You don't accept him as a landlord, but the fact that the property has been sold and the fact that it has been intimated to you by the ex-landlord is not in dispute. Correct?
So if the document itself is for 21, then also.
Sorry?
If the document itself is for 21 and he says that absolutely there is no document, and he himself, when he comes in witness box, he himself says that I have never given any money receipt to him, to me, that I only have my own account, and that account of his does not tally with the monthly rent which he is paying. That is all. I'll not say anything else.
Interesting है, कुछ तो judgment होना
हाँ.
चाहिए. चलिए, क्या बोलना है?
So far as
What do you say to this adducing of evidence on the last day?
actually it was exhibited only because it was a certified copy. The factum of sale was neither disputed by the defendant in his WS, he has constantly stated that the sale is illegal, and therefore the second question, substantial question of law, whether there is a requirement of atonement, whether the tenant has to atone to the sale for that sale to be valid. And that issue has already been decided by the apex court. The judgment has also been relied upon in the first appellate court judgment, that the Supreme Court has already said that reading the provisions of section 109 of the Transfer of Property Act and the Supreme Court judgment, there is now no requirement of atonement to the sale by the lessee. So whenever there is a sale, the rights,
So you
he
want to
steps into
say,
the shoes.
you want to say that this particular document sale deed, execution of sale deed is not in dispute, and therefore it could have been exhibited even at the last stage and taken out.
And because it was a public document, and that is
No.
the second part of
And
the
public
question.
document in the sense ऐसे थोड़ी होता है कि कोई भी public document लाके कभी भी यहाँ पे भी ले आइए फिर public document, right? At best you can say that this particular document, the sale deed by itself is an admitted document because sale deed was executed. He has not denied execution of the sale deed, and merely because it has been produced before the court, it could have been done.
Yes. And it was marked exhibit because it was the certified copy, which as per now section 65 Evidence Act says can be given without the requirement of production of the original, read with section 57 subsection 5 of
There is no
the
problem on
Registration
that.
Act. So therefore that part, because there was no requirement of formally introducing it into evidence and getting it proved, it was treated as a public document because it was the original certified copy. That is to the second part. That's to
What
whether
happened to issue number 4?
issue number 4. My client was there in court yesterday. I had taken instruction. He said that he has lost this property for last more than 14 years. Even if he has to give up, he is willing to take 21.95 if that is the case. But because he's already fought for almost more than a decade, he says that even if what I have purchased I get, I am willing to accept it. If it is that part only. But there is a statement exhibit 2 by the previous landlord who has stated all the plot numbers while mentioning that I have sold all the plot numbers, which was received by him immediately after
This exhibition of the sale deed, has it, in fact, it has helped the applicant.
Yes, it has actually. Because those 12 decimals extra land, now it has created a cloud regarding the ownership of that 12. But even otherwise, it is settled law that the tenant cannot challenge it. Initially, they did not challenge it. It was beyond their pleadings also. They never said that there is an area dispute. Though they have mentioned in reply to the legal notice received from the defendant that there are certain additional structures which are not mentioned in the sale deed, leading to the implied interpretation can only be, or the appreciation of evidence will only lead to the conclusion that he was all along aware of the contents of the sale deed, because the factum of sale was.
If he has to be evicted with respect to 21.95 decimal of land only, then how will it be earned?
It can be done because both the maps are there, both the deeds are with the maps. The original lease deed has a map, and the sale deed which has been exhibited subsequently also has a map. So it can be done according to the map by comparing the maps. The plot numbers are there, except one plot number 326B is missing, and there, in relation to 325B, there is a smaller area. In the lease there was 18 decimals, here it is 11.95 decimals. And there is a map in both the
Total in the lease deeds is how much? 34.
34.
And in the sale deed it is 21.9.
95. That is the only difference. The 10.25 difference is there, but otherwise also I don't know if they want to retain it. They were running an industry. Their evidence was that they are running a biscuit factory, biscuit manufacturing factory. if they want to retain it, otherwise also. But the previous landlord had mentioned there is a related also. He has admitted that he was the person who has purchased it through a company. The authorized person is his nephew, the original landlord's nephew. The landlord says, I have sold the entire property. It could have been a mistake regarding the measurement. Lands are encroached at times. The sale deed happened after more than 10 years from the date of execution of the lease deed. So these could have been possible factors for a difference in the area of the leased premises. So the judgment, Lordship, on requirement of atonement, the 2015-13 SEC, page 30, that there is no requirement for atonement, particularly specifically paragraph 15. 15 and 16. Particularly 15. The question so 109 has been extracted from TP Act, so and so, and then from perusal of the
Para number?
paragraph number 15.
You read para 13.
On the question of
Para
tenants.
12 and 13.
Paragraph
12 and 13.
12. Paragraph. From the definition of landlord, it is clear that the definition is couched in very wide language, according to which not only the owner but also any person receiving rent, whether on his own account or on behalf of or for the benefit of any other person, or as a trustee, guardian, or receiver of any other person, is also the landlord. However, for the purpose of eviction of a tenant on the ground of personal need or reasonable requirement, one must show that he is the owner of the building. A similar question came for consideration before a three-judge bench of this court in so and so the matter related to Bihar Building Lease Rent Eviction Control Act 1947. It is the same act here in 2000 Act. Definition of the expression landlord is similar as that of the Assam Rent Act. Further, the ground for eviction of personal necessity is also similar to that of the Assam Act. Considering these provisions, this court held, therefore, while taking advantage of the enabling provision enacted in section 11(1)(c), the person claiming possession on the ground of his reasonable requirement of the leased building must show
That's
that.
it. You just come to the relevant portion.
Paragraph 15 particularly deals with the question which has been framed regarding atonement.
Paragraph number?
On paragraph 15.
Yes.
On the question of tenancy, both the trial court and the high court have not considered the provisions of section 109 of the Transfer of Property Act, rights of lessor's transferee. If the lessor transfers the property leased or any part thereof or any part of his interest therein, the transferee, in the absence of a contract to the contrary, shall possess all the rights, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it, but the lessor shall not, by reason only of such transfer, cease to be subject to any of the liabilities imposed upon him by the lease, unless the lessee elects to treat the transferee as the person liable to him, provided that the transferee is not entitled to arrears or rent due before the transfer, and that if the lessee, not having reason to believe that such transfer had been made, pays rent to the lessee shall not be liable to pay such
Transfer
rent
property
over again to the transferee. The lessor, the transferee and the lessee may determine what proportion of the premium or rent reserved by the lease is payable in respect of parts or transferred, and in case they disagree, such determination may be made by any court having jurisdiction to entertain a suit for the possession of the property lease. From perusal of the aforesaid section, it is manifest that after the transfer of lessor's right, in favor of the transferee, the latter acts on the rights and liabilities of the lessor in respect of subsisting tenancy. The section does not insist that the transfer will take effect only when the tenant atones. It is well settled that the transferee of the landlord's rights steps into the shoes of the landlord with all the rights and liabilities of the transferor landlord in respect of the subsisting tenancy. The section does not require that the transfer of the right of the landlord can take effect only if the tenant atones to him. Atonement by the tenant is not necessary to confer validity of the transfer of the landlord's rights. Since atonement by the tenant is not required, a notice under section 106 in terms of the old terms of lease by the transferor, transferee should have been landlord, would be proper, and so also the suit for agent.
What is old 106? This is corresponding to new 109. What is old 106?
Old means must be the old act. Moreover, here also the term landlord has been widely defined in the JPC Act of 2000, because here the proceeding was under the 2000 Act, not the 2011 Act.
There is not even a chit of paper regarding giving rent
There is no
to the ex-landlord or to you
no, but the
post
fact
transfer. Only that one document.
yes. Only that the document, the statement of the PW1, which is the subsequent purchaser, who has made a statement, but it has been believed by both the trial court and the first appellate court because it is attendant with the circumstance of his not paying rent. He has paid rent money order only for 1 month, and that too immediately when he is informed the subsequent month. But he does not, his conduct of not paying the rent to the previous landlord, had he paid the rent for the entire period up to the date when the lease was to lose its validity in the year 2011, it could have been believed that he had disowned me as his landlord. He continued to believe bona fide that the person who had given him the lease continues to be his landlord. So therefore, those factors have been considered, and seeing the document, the account book maintained, the document was there, the book was produced, the extract was taken as exhibit. The court believed that the documentary evidence and the evidence may not have been signed, but he was aware. And his being aware in exhibit 2 is also another factor, that he had cleverly neither paid rent to the plaintiff or his previous landlord. Otherwise, there are enough provisions in the Act, and there is a specific provision that if there is a doubt regarding ownership, he could have even gone and deposited under section 18 of the JBC Act 2000. It says that if you believe that there is a genuine dispute as to who your landlord is, then you can deposit the money, the rent, with the controller. And the controller can be called upon to, in the nature of an interpleader suit, that I am not defaulting, I am paying. And here there are multiple grounds for eviction, not just one. It is not just bona fide, the personal requirement. This is a company doing business. Therefore, the eviction is on all 3 counts. One, the original lease has already expired. Second is that there is default in payment of rent. And third is personal necessity. So on all 3 counts. So
Personal necessity has also been allowed.
Personal necessity has also been allowed. All 3 counts have been allowed.
देखिए हर्ट आपको कुछ बोलना है?
Now, your lordship, whatever judgment he refers, that refers to if the lessor transfers the property, lease, or any part thereof, or so regularly the word transfer word has been used. Transfer word cannot be read in isolation. Transfer means transfer in terms of what is required under Transfer of Property Act and Registration Act. So if the merely because the my lessor says that he has transferred the property, would that mean that I was bound to acknowledge the new owner as the landlord of the property? I was not. transfer has to be in terms of what is there in Transfer of Property Act. And what is there?
There is a
Transfer can be only by way of a registered instrument, and that too, therefore the sale deed was very important. Therefore sale was important. So entirely he is relying on that sale deed portion. Again, that cannot be. If that is taken out, then it has to be taken out completely.
Because if it is taken out, it
So
should be
if-
taken out completely.
Yes, yes.
Certainly.
So merely because the landlord
can't
says that I have transferred and he has actually not transferred, then what would happen? Then whether I am bound to acknowledge my new landlord as the person whom he is saying as a new landlord. When I am saying that I am not acknowledging you, that is sufficient.
And you only read the
And
definition of
Your
landlord.
because this word regularly it has been used that it is a public document, and therefore he admits it at the time of judgment itself. Now, Evidence Act, entire Evidence Act is regarding as to what would be how the evidences would be evaluated, how they have to be produced. That is there in CPC. Complete mode has been given so that the parties got a full opportunity to place their case. That is the hope.
Heard the learned counsel appearing on behalf of the parties. This appeal has been heard, has been admitted for final hearing. By order dated 31/3/2022 on the following substantial questions of law. The learned counsel for the appellant has, while referring to question number 1, the learned counsel for the appellant has submitted that the registered sale deed has been wrongly admitted in evidence on the date of judgment. He has referred to Order 7/14 of CPC to submit that the sale deed, which was basis of the claim of the plaintiff, was to be produced, a copy of which was required to be produced while filing the plaint, and anything subsequently can be introduced only with the leave of the court. He has also submitted that as per Order 13 Rule 1 CPC, the original document is also required to be filed. The learned counsel submits that the manner in which the sale deed was admitted into evidence is unknown to the provisions of CPC, and therefore the same could not have been taken into consideration. He has also submitted that if the sale deed is excluded, then the basis of the case on behalf of the plaintiff fails, and consequently the appeal is to be allowed. The learned counsel has also submitted that merely because the same is a public document, the same cannot be adduced in evidence in the manner it has been done, inasmuch as there was no occasion for the appellant tenant to cross-examine the witnesses of the plaintiff with regard to the nature and the extent of sale deed. He has also submitted that the sale deed in the present case cannot be said to be an admitted document. With regard to the learned counsel submits that in case the sale deed is excluded from the evidence, then none of the parties can rely upon the same. During the course of hearing, by referring to substantial question number 4, which relates to area covered under the sale deed, it transpired that apart from the sale deed, there is no other material or evidence on record to substantiate as to what was the area of the property covered under the sale deed. Thus, it is not in dispute from the side of the appellant that if the substantial question number 1 is answered in favor of the appellant, then the issue number 4 need not be answered. Correct? Yes? Correct? This is it?
This is difficult.
This is what I have asked you. It can't be answered. Show me anything from the record apart from this. Nothing. नहीं है ना, कुछ भी नहीं है, हम पूरा देख लिए। आप भी देखिए।
नहीं, हम देख लेंगे बट यू लॉर्डशिप एक और था।
अब क्या बचा?
नहीं, एक जजमेंट है वो हम ड्यूटी ऑन टू प्रोड्यूस। Correct law must be placed there. Now, time and again this question comes up. What would be whether a sale deed is a public document? Recently, Honorable Supreme Court in Deccan Paper Meets, particularly paragraph 22, it said that sale deed, although it may be records of which may be kept by the public office, but they are not by themselves public document, and they are private document, and the certified copy is also.
The learned
I have a
counsel.
contrary judgment. 22 judgment.
Just a minute.
23.
The learned counsel for the appellant has also submitted that merely because sale deed is a registered document, that by itself does not become a public document. However, he submits that he shall provide a copy of a judgment in support of this argument within a period of 2 days from today. Right? The learned counsel has submitted that in case the sale deed is excluded, then the matter has to be considered on the basis of materials available on record. The learned counsel has further submitted that the appellant never acknowledged the respondent as the landlord and was remitting rent to the previous landlord and never paid rent to the appellant, to the respondent. He has also submitted that the previous landlord has not deposed before the court to deny the remittance of rent by the appellant to the previous landlord through money orders. He has also submitted that it was a case of the appellant that the previous landlord at times used to refuse acceptance of the rent through money order. That's all? हो गया ना? तो कुछ बचा नहीं है आपका? The learned counsel appearing on behalf of the respondents has submitted that the sale deed was not in dispute. He has also submitted that the appellant was only disputing that the sale deed could not have been executed as there was a lease deed in favor of the appellant. The learned counsel has also submitted that the sale deed being an admitted document on record, being admitted could have been taken into evidence even at the last stage as the sale deed, as the execution of the sale deed was not in dispute. The learned counsel has further submitted that the appellant was a rank defaulter. No evidence has been placed on record by the appellant regarding remittance of rent to the previous landlord, as the appellant had claimed that he continued to remit rent to the previous landlord till the expiry of lease in the year 2011. The learned counsel has also submitted that has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2015, bracket close 13, SEC page number 13, paragraph 12, 14, 15 and 16, to submit that there is no need for the landlord to atone the tenancy, for the tenant to atone the tenant, sorry?
To atone to the sale.
To atone to the sale. he has submitted that by the exhibit 2, the previous landlord had intimated the appellant regarding the sale of the property, and both the courts have come to the conclusion that the appellant did not pay rent. The appellant was defaulter with respect to payment of rent to the appellant, to the respondent, who was the subsequent purchaser of the property. He has also submitted that the appellant had paid rent to the respondent to some extent, but subsequently he stopped payment of rent. He has also submitted that the appellant under section 18,
19.
sorry,
19.
19 of the
Of the
Jharkhand of the JP
Jharkhand Buildings Lease Rent and Eviction.
Jharkhand Building Lease Rent and Eviction Control Act 2000 could have deposited the rent before the rent controller in case of any confusion as to who is the real landlord of the property. The learned counsel has submitted that the appellant is enjoying the property without paying rent, either to the without paying rent at all. He has also submitted that the appellant had also issued a letter to the respondent seeking renewal of lease. ठीक है? यही आपका?
And because he has raised it subsequently, that
The
whether it
learned
can be
counsel has
public
also
document or not.
submitted, has relied upon the judgment passed by the Honorable Supreme Court reported in, बताइए citation, reported in 2023 SCC Online SC 1183 to submit that the registered sale deed is a public document. What about issue number 4? Nothing.
Issue number 4, I can only say exhibit 2, since the exhibit 2 mentions the entire property and the definition of landlord, any person who.
The learned counsel for the respondent has also submitted that the definition of landlord is wide enough to include any person to whom the property has been transferred. The previous landlord had informed the appellant that the entire property has been transferred to the respondent, and therefore there is no question of not remitting rent of the entire property to the respondent. That's all. That's all. Arguments concluded. He has also submitted that there is a concurrent findings recorded by both the courts that the appellant is a default. Let's see, कुछ तो करना ही पड़ेगा. चलिए ऑर्डर्स केस कॉल करें. हाँ इस पे डेट एक जजमेंट के लिए डेट नीचे. जो होली के पहले एक रखते हैं ना वही डेट. चलिए
From submitting this for order item 4, first appeal 451 of 2018.
आप बताइए only for delay? How much?
15 days, 3 days, as per my.
Sorry?
15 days, and the reason has been stated in the meeting.
रीजन तो हम पढ़ेंगे क्या आप बताएंगे?
हम बता रहे थे.
हाँ तो बताइए.
The reason is that he
आइए नंबर कौन सा?
3993.
As per the office note, it is अपील का नंबर बताइए. FA नंबर
451 of 2018.
451 of 2018. Delay है 1503 days. What is the reason? आइए नंबर कितना है?
3993.
3993 of
2021.
2021. हाँ बताइए क्या प्रॉब्लम है?
reason is that he, in the, I'm going back to the history matter. In the year 1952, the land, a big chunk of land of 4 villages has been required by the government.
for the purpose of
इसके लिए लिमिटेशन में हिस्ट्री क्या देना है?
for the reason that's why I am stating my
क्या रीजन है? पुराना इतना 52 का हिस्ट्री.
history was कि when the award was passed by the Honorable Mr. Bharatiya was the arbitrator in this case. So then the party moved to before the Supreme Court for enhancement. So when the
Exemption हो गया.
exemption हो गया, then they come forward, they gathered courage and they came the 48 persons in the batch. They came we also want to fight this first. So that is the reason for the tournament. When exemption was granted, they gathered courage and they came before this court. Because prior to that,
क्या बोलना है?
up to 5 decades, no compensation has been paid, and even the two generation has been gone and without the compensation.
Yes, what is?
Madam, we
No
have-
compensation has been paid.
No, but the payment of compensation was made, madam. Thereafter, madam, they made an application for the purpose of appointment of arbitrator. Subsequently, madam, the order of the Supreme Court, the appointment of arbitrator was made. Therefore, madam, the award has been passed. It is not a case, madam, that compensation.
That's
is
right,
not-
by virtue of the orders of the High Supreme Court.
Yes, madam, the appointment of arbitrator was made, madam.
That's right.
Now,
The
thereafter,
awarded amount has been paid.
madam, so far as the awarded amount is concerned, madam, that I have to take instruction, madam, with respect to that part, whether it has been deposited or not.
We don't need to bother about it.
No, but the fact remains, madam. that-
Possession has been taken.
Pardon, madam.
Possession has been taken.
Lord, the case is, Lord, so far as the case is concerned, Lord, 1941-42, Lord, the case, the land was requisitioned, Lord. Thereafter, Lord, in the year 1971-72, Lord, it was acquired. Therefore, it is under the Requisition and Acquisition Act, Lord, this land has been acquired, Lord. Subsequently, Lord, in terms of Requisition and Acquisition Act, Lord, in section 8 provides with respect to payment of compensation. Lord, after lapse of several years, Lord, they made an objection with respect to them that the entire amount has not been paid. Lord, that issue, Lord, the Honorable Supreme Court has said that unless there is a writing agreement to that effect, therefore the arbitrator is to be appointed for determination of the compensation. Accordingly, Lord, the arbitrator has been appointed and the amount has been considered with respect to 4 villages. That has been determined, Lord. The amount which has already been deposited, the amount which has been already paid, all these things, Lord, that is a matter of calculation. That has not been done, Lord, in terms of the award itself, Lord. What is happening, that has not been brought on record. But the fact remains, Lord, there is one set of case which has been filed with respect to that part in which, Lord, there was an exemption. It is not an exemption, in fact, it is a deferment of the court fees which has been passed, that it will be adjusted when the award is to be given. Lord, thereafter, Lord, these cases have been filed. Now, you not kindly come to my objection which we have filed in the.
There is that order where there is a deferment.
Absolutely. That has been deferred.
And this appeal was filed when?
Well, this file, it was filed in 2018.
And when was the order of deference passed?
That is what it was.
And the award passed on 30/10/2000.
When was the order deferring the court fees has been
That
passed?
was passed on 2/12/2020 2020 by Honorable Justice Mr. K.P.
So, but it was, this case was filed prior to that.
Yes,
Then
that cannot
then
Uh,
be.
your entire plea.
Prior to that, I don't have the judgment order matter. Honorable Justice Rajesh Kumar has deferred that prior to this order. So it has been mentioned, I may be permitted to read out what the lines are.
So far as court fee is concerned, the project bench of this court already that has been deferred, has already passed an order that deficit court fee will be deducted from the amount of compensation. Then only the rest amount will be released to the claimants.
Where is that order? In this case also?
In this case, it is
Yeah.
in first appeal number 445 of 2018.
Single order for all the cases has been passed.
All-
All these where
all
matters.
cases
In all
are-
these cases, you have not paid the court fees.
No, not a single. No amount has yet been given as compensation, my lord, after lapse of 70 years.
No, I just want to know. The court fees is still deficit.
Yes, ma'am.
Limitation petition has been filed, but there is no.
The stamp reporting.
The defect regarding court fees is still existing.
In this case, that order is not.
In particular, in this case, but matter is same. Everything is common.
But you are not making a prayer to pass an appropriate order here.
Petition
In this
is
case.
required to be filed in the
As per I said, already apparent from the order, my lord, I am permitted to read out the order.
But all the cases, it will be
In all the
accepted.
cases, all the cases have been limited to matter. Here specifically,
petition.
batch of 48 cases, and that is in page 7 of the order, my lord. Honorable Justice Mr. K.P. Jain.
This case is included in this list.
Included in that.
So there is already an exemption.
My lord. Packet. 445
This is 451.
Just reading maybe.
Yes, it is there. 451 is there. देखिए। आपको और कुछ बोलना है कॉन्बिनेशन ऑफ डिले का?
Well, I have objected so far that part is concerned.
Already, the Honorable Supreme Court in the year 1993 has already held that the government to appoint an arbitrator and expeditiously as possible at any rate, because already 25-30 years have elapsed in the year 1990.
First appeal number 451. This is 451. 451. First appeal number 451 of 2018. Heard the learned counsel appearing on behalf of the parties.
But just a minute.
Yes.
But I am submitting so far as that point is concerned, which has been taken in this case. But we have mentioned in our rejoinder with respect to the fact, so far as the affidavit which is being said to be filed with respect to the IA application. But we have made an objection in paragraph 3 of our rejoinder to the effect, so far as the delay is concerned, that has been shown to be 2481 days. Because the application was filed, the appeal was filed without application of the limitation petition. And there was delay, so far as that part is concerned, there is 933 days delay. And if that is being counted, then it comes to 2481 days. That I have mentioned in our rejoinder. And therefore, there was a complete lack of bona fide on the part of that cannot be said to be a bona fide. There was judgment. So this is the para 26 of the judgment. The vicinity of the Supreme Court has considered this and taking into consideration not the principles which is being said to be reiterated.
Which paragraph are you referring?
All are reference Roman 6 would be not so far as that part is concerned.
Read it, please.
Merely some persons obtain relief in similar matter, it does not mean that the others are also entitled to the same benefit. If the court is not satisfied with the cause shown for the delay in filing appeal. Here, because there was an exemption and therefore they have filed, this is their specific case. Therefore, only because of some of the persons having the same award that has been there, that will not entitle. Because of the fact that the award was given in 2014, 4 years they have not done anything. And neither they have explained with respect to that period anything with to that part. Therefore, section 11, which the proviso of section 11 of the Revision and Admission Act
which empowers with respect to the filing of appeal, my lord.
Act का नाम बताइए.
Requisition and acquisition of immovable property Act 1952. This award has been passed under this act only. Madam, can
What
you
does
see
it say?
for a moment, please, very small.
11.
Section 11 provides, madam. Section 11 speaks about filing of the appeal within 1 month. The period of limitation is 1 month. And you will also take into consideration the sufficient cause which is required to be shown. Sufficient cause which is required to be shown. That is the most important part which is to be taken into consideration for the purpose of therefore, my lord, the prevention with respect to the cause which is required to be given, my lord, that has not been explained by the applicant during the period from the date of award after expiry of 1 month and thereafter, my lord, the 4 years, my lord. So far as that part is concerned. My lord, in absence of any explanation to that, directly coming to the effect, my lord, that there was an exemption with respect to filing of court fees or with respect to that part, that cannot be the only ground for the purpose.
Your appeal has also been admitted.
Pardon?
367.
Yes, my appeal is also admitted. Therefore, I am saying, not so far as the clause 6 is concerned, Honorable Supreme Court's observation.
In the award, it's stated manually in the last paragraph. Right? The awarded amount at G must be paid to the claimant and users in the manner specified again by 31/01/2015, and till date it's now again 2025. So already after passing of the award, 10 years has left, and not a single has been paid to the claimant's mallet since last 70 years.
Yes. FA number 451 of 2018. For the Learned Council appearing on behalf of the parties in IA number 3993 of 2021, seeking condonation of delay in filing the appeal. As per the office note, the delay is for a period of 1503 days. The appeal was filed before this court on 29/11/2018, and the petition seeking condonation of delay was filed on 26/6/2021. In the meantime, an order dated 2/12/2020 was passed by this court, observing that the Union of India through Defence State has also preferred appeal against the award, which is numbered as first appeal number 367 of 2018, and by the state order, it was by the state order, so far as payment of court fees is concerned, the same was to be deposited. The deficit court fees was directed to be deducted from the amount of compensation which may be received by the appellants. The Learned Counsel for the appellant, while referring to the petition for condonation of delay, has submitted that the appellants are land users, and in spite of the award, nothing has been paid to them so as to enable them to pay the court fees, and consequently the aforesaid order has been passed on 2/12/2020. He has also submitted that once the said order was preceded by another order passed in first appeal number 203 of 2014, dated 31/8/2018, wherein also similar order was passed. He has submitted that as soon as that the appellants are daily wagers and are extremely poor people, and some of the land users are even out of their village, and therefore they could not file appeal within time. And once they came to know that the court fees can be exempted, then under such circumstances they immediately took step and filed the present appeal. And upon pointing out of the defect and after seeking exemption from payment of court fees, the petition for condonation of delay has been filed. The Learned Counsel, appearing on behalf of the respondents, has opposed the prayer. Respondent Union of India has opposed the prayer by submitting that if the date is taken till the date of filing of the petition for condonation of delay, then the delay would be 1548 days. The appellant has not explained the delay in filing the petition for condonation of delay in the present case. He has also relied upon the judgment passed by the Honorable Supreme Court in civil appeal special leave petition with bracket civil number 31248 of 2018. Article नाम दे देंगे. Paragraph 25, para 26 point Roman 6 to submit that merely some of the persons has obtained relief in similar matter, the same does not mean that the others are entitled to the same benefit if the court is not satisfied with the cause shown for the delay in filing the appeal. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that an order dated 31/8/2018 was passed in first appeal number 203 of 2014, wherein it was directed that the deficit court fees will be deducted from the amount of compensation, and then only the rest of the amount will be released, if any, to the claimants. This court finds that specific averment has been made in the petition for condonation of delay that the appellants are very poor persons. Some of them are even out of village and are daily wage earner. This factor has, and they were not able to approach this court because of poverty. This factum has not been denied by the respondents in the counteractivity. This court is of the view that the poverty by itself is a disability, and due to which the appellants were genuinely prevented from approaching this court by filing the first appeal. So far as the judgment relied upon by the respondents is concerned, this court also finds that considering the genuineness of their demands, this court has also passed order dated 6/12/2020 in the same line as that of first appeal number 203 of 2014. So far as the genuineness of the so far as the judgment which has been relied upon by the respondents, this court is of the view that the appellants, that none of the claimant have actually obtained any relief, and the matter regarding compensation is under challenge not only in this batch of writ petition, this appeal, but even Union of India has filed an appeal arising out of the same award, and therefore and further this court is satisfied with the cause shown by the appellants in delay in filing the appeal. Considering the totality of facts and circumstances, this court is inclined to condone the delay. The delay in filing the appeal is hereby condoned. आइए allow. Admit.
This one is just to be admitted.
Admit. Call for the records from the concerned. किसके पास से आएगा? From the learned arbitrator. Original records मंगा लें? Original records from the learned arbitrator. That is all. कब करेंगे
So
बताइए?
for the other cases, then it's a
Same चीज़ है
same
सब.
order is to be passed over. Thereafter, no काम वाली question is to be made. But after admission,
अलग अलग तो नहीं है, सब तो सेम ही है, सब एक ही, सब सेम डेट में रख देंगे.
हाँ सब चेंज में रख दीजिएगा, हम उसके लिए नहीं बोल रहे.
There is already an order of call for records matter. FA number.
आया है रिकॉर्ड?
इसमें नहीं है, another case. Previous batch number.
कौन सा प्रीवियस बैच?
FA 203 of 2014.
ये भी सेम.
एक ही award में.
एक ही award.
There are 631 cases in the injunction.
2014.
There are 631 cases.
Just कहाँ है इसमें? Put up this case after 8 weeks receipt of LCR. देखिए.
वो specific order लगता नहीं है.
The learned counsel for at this the learned counsel for the appellant has submitted that in FA number 203 of 2014 there is already an order for calling for the records from the LCR, but he submits that the records has to come from the learned arbitrator who has passed the improved award. Office is addicted to call for the records of the case from the learned arbitrator if it has not been received in the records of FA number 203 of 2014. ये सारा केस सेम ऑर्डर, सबका आईए नंबर, सब में एग्जेम्पशन है, सब में एग्जेम्पशन है, कोई और डिफेक्ट है किसी में?
मेरे ख्याल से फर्स्ट केस में
हाँ उसको देखते हैं, उसको आई जस्ट
उसमें डिफेक्ट है.
उसमें डिफेक्ट है, अभी करते हैं. और जो बाकी सब तो हो गया, सीरियल नंबर 2 से सब हो गया. हाँ ठीक.
सप्लीमेंट्री और डेली रिव्यू.
हाँ
ये डेली का फर्स्ट दिक्कत.
आप एक काम करेंगे, सारा रिकॉर्ड चेक करेंगे, वो गोरा जी को रिकॉर्ड सारा चेक करेंगे, सारा का सारा आईए नंबर देंगे, सबमिट नंबर ऑफ डेज का डिले चेक करेंगे, सारा कुछ चेक करके ही ऑर्डर होगा, है ना? ये बताइए इसका फर्स्ट अपील, ये डिफेक्टिव है 486. 486 में दो आईए हैं. एक तो वो बोल रहे हैं कि डेथ हो गया है, सो दे वांट टू परस्यू द केस. यू गेट दैट? ये क्या ये फाइल किया है बताइए?
Substitution is one.
ऑर्डर 41 रूल 1 का क्या पिटीशन फाइल किया? डिस्पेंस विद फाइलिंग ऑफ सर्टिफाइड कॉपी. किसमें है सर्टिफाइड कॉपी? किस रिकॉर्ड में है?
In 486 2018. First
इसी बैच में है ये?
486 तो यही के ऑर्डर.
नहीं
486 में सर्टिफाइड कॉपी. 486 में सर्टिफाइड कॉपी फाइल है, तो इसमें आइए क्यों फाइल किया? कुछ भी नहीं पता है. जितना गरीब है आपका क्लाइंट उसको और गरीब मत बनाइए. बताइए इसमें फाइल हुआ 486 में. एक में कौन सा कोड रिकॉर्ड हम देखें? तो फिर इसमें आइए इंस्ट्रक्टर से डिस्कस कर लेते हैं.
लास्ट टाइम भी और कोड नंबर 9 में ये ऑर्डर हुआ था इनको.
कहाँ है आपका सर्टिफाइड? सप्लीमेंट्री अवार्ड. Certified copy of the judgment. देखिए, learned counsel for the appellant submits that. आइए नंबर कुछ नहीं पता. आइए नंबर बताइए. आइए नंबर 7.46 of 2019 has been filed, seeking exemption from filing certified copy. However, he submits that the certified copy has been filed in this record itself, and therefore he does not want to press the interlocutory application. Considering the submissions, IA number 7146 of 2019 is dismissed as not placed. Next आइए बताइए substitution.
4039.
IA civil number 4039 of 2021. This petition has been filed for substitution of legal years in terms of Chapter 12, Rule 97 within bracket league capital of the High Court of Jharkhand Rules 2001. The Learned Council has submitted that the awardee number 1, namely Mahadev Oraon, in first appeal number 486 of 2018, and award number 88, died leaving behind his legal years on 14/7/2016 after the passing of the award. He submits that the legal years have been made appellant as Bandan Oraon and Tuntun Oraon. He submits that the office defect in that connection being considering the submissions. The कुछ objection है आपको? The Learned Council for the respondents has no objection to the prayer made through the CTBT application, considering the submissions IN within bracket civil number 4039 of 2021 is hereby allowed. The office defect in connection with the party position with respect to Bandan Oraon and Tuntun Oraon and Mahadev Oraon having not been made party is ignored. और बताइए और एक क्या लीले सेम स्टोरी लीले कंडोन कर दीजिए इनका आईए नंबर है 4038 of 21. इसमें लीले कितना निकाला है इसमें As per office note, it is 1503 days. ठीक है, same students, everything is same. तो ये भी admit, ये सारे matters are to be tagged. All these matters are arising out of the same award, and therefore they are tagged.
All the pending matters which are not on board. Either they should case all those cases be listed one day alone and they should be tagged.
बताइए.
Recently on 8th of January, the office has informed that the substitution petitions IA has not been disposed of. Due to that reason, all cases are dismissed for default.
तो क्या करें हम? क्या करें आपके केसेस का?
Already my IA was pending.
IA पेंडिंग है तो मेंशन कौन करेगा उसको? IA पेंडिंग होने से आपका केस ड्यूटी नहीं होगा? यस? एक तो वो लोग इतना दिन लेके बैठ गए उनको समझ ही नहीं आ रहा था क्या करना है और आप भी सो रहे थे आपको भी नहीं होश है हाँ अब नेक्स्ट जनरेशन क्या 3 जनरेशन और बीत जाए केस डिसाइड आप ये जो है ना स्पेशल मैसेंजर कॉस्ट जमा करिए इसका ठीक है एक केस में जमा कर देंगे ठीक है ये रिकॉर्ड्स भी कॉल फॉर अपॉन डिपॉजिट ऑफ स्पेशल मैसेंजर कॉस्ट आप यहाँ पे जमा कर दीजिए
पहले वाला जो केस में ऑर्डर किए थे
उसी में एक ही केस में रिकॉर्ड आएगा सब हो जाएगा काम बस आप तैयारी करिए वैसे उसको आप और लोगों को मरने मत दीजिए पोज दिस केस ऑन 12th of February in the supplementary cost list. बस अब आप लोग तैयार आपका केस क्या हुआ डीएफडी हो गया आपका नोटिस फाइल करना था हो गया हम लोग तो रिमाइंडर भेजे आपको
नहीं फाइलिंग टाइम नहीं मिलता
फिर भी लास्ट मोमेंट तक वेट करते रहेंगे क्या
नहीं तो अब तो डिपार्टमेंट को बोला हुआ है उसके अंदर डिपार्टमेंट प्रोसेस कर रहा है
वी सेंड यू अ रिमाइंडर आल्सो आपके पास आया था रिमाइंडर
एवरी वीक वहां कांटेक्ट कर रहे हैं उन लोगों को बोल रहे हैं
अच्छा है ना इस बार रेस्टोर भी नहीं करेंगे आपका केस ये सोचिए कि जो आपको देना है कम से कम वो तो दीजिए इतना पुराना अवार्ड लेके क्या ही ग्राउंड पे आप लोग चैलेंज कर रहे हैं यू जस्ट टेल अस अभी सुप्रीम कोर्ट का ऑर्डर आया है ना न्यायालय ऑर्डर आया है ये कोई ग्राउंड है आप लोग का
there are certain things which I cannot say at the moment. Otherwise, this case is concerned for last 6 months. I have pursuing to the department. The Ministry of Defence is literally every week there is a conference for an online conference is concerned.
देखिए ये सब चीज़ का कोई मायने मतलब नहीं है, ये सब अननेसेसरी लिटिगेशन है, कम से कम आपकी तरफ से।
There are certain administrative hassles which we cannot overcome so far as the part is concerned.
DFD हो ही जाएगा हो ही जाएगा,
नहीं होना चाहिए।
अच्छा है,
But-
हो जाएगा तो हम उसको रेस्टोर होने का वेट नहीं करेंगे, ये केस हम
हाँ।
डिसाइड करेंगे। कब है आपका लास्ट डेट उसमें?
मार्च में, फरवरी में खत्म।
फरवरी कब?
फरवरी में सर 9th को।
9th को ना, अच्छा है, कौन तारीख को रखें?
12 को रखें।
बस 12 को इस केस को हम लोग को डिसाइड करेंगे। और भी कोई मैटर्स हैं इसमें?
So there are total 631 cases probably my land friend is saying.
बाकी सब DFD हो गए, बाकी सब इनका
Only
DFD।
371 appeals in first batch has been filed and 48 in second batch. That's all.
बस
Means
ये तो हम लोग का 12 तारीख के लिए मैच्योर कर जाएगा ना।
425 cases.
Post this case along with first appeal number 203 of 20 करवाते हैं ना, लिस्ट में क्या ही करना है बताइए।
तो पूरे बैच को एक साथ करवा दिया
वो अलग से बैच है क्या?
हाँ अलग बैच बनाओ, वो पूरे बैच एक साथ करना पड़ेगा। एक
उसको नहीं, निकल कल परसों या मंडे को, मंडे को वो पूरा बैच हम लोग पोस्ट करते हैं।
वेडनेसडे को कर दीजिए, उसको ऑफिस को सुविधा हो जाएगा निकलने। पूरा बैच यहाँ से वहाँ जितना
पूरा बैच का ना,
क्योंकि उन लोगों को छांटना पड़ेगा, डीएफटी जितना हुआ है उसको तो किनारे करना पड़ेगा।
हाँ उसको अलग से हम लोग करके इसके साथ टैग कर देंगे, बस याद रखिएगा 12 तारीख को टैग करना है। 40 में क्या होगा? अब तो क्या ही हम कर सकते हैं। चलिए नेक्स्ट।
Daily sale of 7, it is part of the same national in that he had not been served a copy of IDA limitation.
अब हम लोग कुछ नहीं जानते आपका क्या है नहीं है। यूनियन ऑफ इंडिया ने सब में रिप्लाई फाइल किया हुआ है, कॉम्पनसेशन किसको देना है? तो फिर बस रहेगा ही नेक्स्ट वीक। आप लोग तो आपका डीएपटी कर दिए थे ना, याद रहेगा ठीक है ना। बाद में दौड़ दौड़ के मत जाइएगा, फर्स्ट टाइम कॉल आउट होगा हम केस फिर से डीएपटी नहीं और रिकॉल भी नहीं करेंगे। नहीं। सीरियल नंबर कौन सा है? 14। मिस्टर नाम बताइए। ललित यादव। This case was taken up in the first half when the case was dismissed for default. However, before signing of the order, Mr. Lalit Yadav has come to the court and has requested that the case be taken up. Since we have considered the request as the case has already been admit हो चुका है। We have considered the request and it is directed to be posted on next आज कितना है? Wednesday? Thursday. Next Thursday. ये सब करना पड़ता है ना, सब रिकॉर्डेड प्रोसीडिंग है, बहुत ज़्यादा दिक्कत है हमको इस तरह से ऑर्डर रिकॉल करने में।